October 2021, a truancy officer in Ohio gets a report. 6 students, same family, haven't shown up to school, not once, not a single day, at a school that's 5 minutes from where they live. 5 minutes. That's not a long commute. That's not a transportation problem. That's not a family struggling with distance or resources or scheduling. 5 minutes away. And not one of those 6 had been inside a classroom for a single day. The case gets opened. The parents are contacted. Gary Siders Jr. and Elizabeth Siders are named in the truancy case. Officially, it's in the record. And then, this is the part that I keep coming back to, the part I've been sitting with since I first read it. The case was dropped, not because someone investigated and found an explanation, not because a judge reviewed it and made a determination, because the parents stopped responding. They simply stopped answering, stopped picking up, stopped engaging. And at some point, whoever was handling the case decided there was nothing left to do. The case closed. 5 years later, on June 30th, 2026, law enforcement officers arrived at 182 Omer Road in Hamden, Ohio, to serve a misdemeanor warrant on Gary Siders Jr. and found 16 individuals living in conditions that the Ohio Attorney General described as extraordinarily serious. 2 were transported by helicopter to trauma centers in Columbus. 7 were hospitalized. None were enrolled in school. The truancy case in 2021 was about 6 of them. Not all 16. 6 at a school 5 minutes away. And the case closed because the parents stopped responding. I need you to hold that, not as a dramatic detail, as an investigative fact. Because what I want to do today, what I think is the most important thing this case still has to teach us, is trace the full pattern. Not just what happened on Omer Road, not just the legal proceedings that have been unfolding since July 1st, but the whole shape of this, how far back it goes, what the records actually show, and what the people whose job it was to notice chose to do with what they saw. Let's start with what the Columbus Dispatch found when reporters reviewed marriage and birth records in Ohio and West Virginia. Marriage and birth records, public documents, the kind of thing that sits in courthouse filing systems and government databases and doesn't get looked at until someone decides to go looking. What they found, and what NewsNation confirmed, is this. At least 3 members of the Siders family entered into marriages as teenagers. Not 1, 3. Elizabeth is the one everyone knows about. Elizabeth Russell, her name before she became Elizabeth Siders, married Gary Siders Jr. in Mason County, West Virginia in March of 2008. She was 15. He was 18. Her parents consented. A circuit court judge signed the license, and within 2 months of that wedding, the oldest of what would eventually become 18 children over 17 years was born. But Elizabeth wasn't the first. And that's the thing that's been quietly sitting in the public record, sitting in courthouse files in West Virginia and Ohio. And that has now surfaced in a way that fundamentally changes how you have to understand this family's history. Because before Elizabeth, there was Tessie. Tessie Wright was a teenager when she married Richard E. Siders in Gallia County, Ohio in 2002. Richard E. Siders, who is not the same person as Gary Siders Jr. or Gary Siders Sr. He is another member of the extended Siders family. Tessie later spoke to the New York Times about her late husband. Richard died at some point after the marriage, and described the circumstances of her own situation. She was a teenager. He was significantly older. And the marriage happened in Ohio in 2002 with whatever documentation Ohio law required at the time. State records show that the marriage was legal under Ohio law as it existed in 2002. Just as Elizabeth's marriage was legal under West Virginia law as it existed in 2008. Legal, but not necessarily examined, not necessarily questioned, not necessarily subject to the kind of oversight that might have looked at those circumstances and asked, is this okay? Is this a choice that was made freely? Is there someone here who needs to be asked separately, away from the adults who are consenting on their behalf, whether this is what they want? Those questions weren't required by law, so they weren't asked. And now, in 2026, we are looking at a family where at least 3 teenage marriages are documented in the public record, where investigators have described the household as intrafamily in nature, and where the legal proceedings are only beginning to work through what all of that means. Let me tell you about the third marriage, because the dispatch investigation identified 3, and I want to be honest about what I know and what I don't. The third marriage involves another member of the extended Siders family network. Details on that third case are still emerging, and I'm going to stay within what's been confirmed rather than speculate about the specifics. What's confirmed is that the pattern exists. 3 marriages, all involving teenagers, all within the same family network across a period of years, all documented in official records that were sitting there waiting to be found. This is not ancient history. The 2008 marriage, the one that's the most central to the current criminal case, happened 18 years ago, but it's part of a pattern that predates it. And that pattern is the thing I want to examine. Because here's the question that I think matters most, and that former FBI Special Agent Jennifer Coffindaffer put on the record when she spoke to NewsNation this week. How many red flags were there, and what happened to each of them? Coffindaffer has been analyzing this case from an investigative standpoint, and she made a specific observation that I think deserves much more attention than it's gotten. She talked about the truancy case, the October 2021 truancy case. She said it plainly. That's just unacceptable. When parents stop responding and a case like this gets closed, she said, that's not a resolution, that's a failure. She also talked about the indecent exposure charges against Gary Siders Jr., the 4 incidents in May 2026 that led directly to the warrant, that led directly to June 30th. She said those charges should have been a red flag, not just because of what they were, but because of the pattern they suggested. And then she said something that I've been turning over in my mind ever since I read it. She said, so you had neighbors that were watching. You had neighbors that likely turned him in for this indecent exposure, but they never saw the children. Read that again. Neighbors saw enough to call in the indecent exposure incidents. They were paying attention to what was happening outside that house, and they never saw the children, 16 individuals, living in that house, and in a neighborhood of roughly 700 people, in a village small enough that people know each other's routines. Nobody saw them outside. How is that possible? I think there are 2 ways to answer that question, and I think both of them are probably true simultaneously. The first answer is that the family was deliberate about keeping those in the household invisible. The record avoidance that investigators have described, no school enrollment in Vinton County, limited medical documentation, movement across counties and states over 18 years, that's not accidental. You don't end up nearly entirely absent from government and medical records over an 18-year period by accident. You do it, or you fail to prevent it, which in the context of a family with this structure may amount to the same thing. The second answer is that the systems that should have generated visibility simply didn't. The truancy case closed when the parents stopped responding. The indecent exposure charges created a warrant, but the warrant was for Gary Jr., not for a welfare check on whoever was inside. The state benefits enrollment for Christina and Gary Sr. created government paperwork, but benefits enrollment doesn't trigger a home visit. School homeschooling notifications in Ohio, at the time, required almost nothing in terms of verification or follow-up. Each system had a gap, and the family existed in the gaps. Let me go back to the marriage records for a moment, because I want to be specific about something that I think gets lost in the broader conversation about teenage marriage and consent. When Elizabeth Russell married Gary Siders Jr. in Mason County, West Virginia in 2008, West Virginia law required parental consent and a judge's signature. That's all it required. The law did not require the court to conduct any investigation. It did not require a guardian to be appointed to speak independently with the younger party. It did not require the judge to ask any questions beyond confirming that the legal requirements were met. West Virginia family law attorney Amanda Alexander said publicly that the judge who signed that certificate absolutely could have stopped it. Not that the judge was required to stop it, that he had the authority to ask more questions and chose not to. And this is the thing that connects the 2002 Tessie Wright marriage and the 2008 Elizabeth Siders marriage, and whatever the third documented teenage marriage was. They all happened inside legal frameworks that permitted them. Frameworks that have since been revised, or that jurisdictions have since moved to tighten. But that existed, at those moments, in ways that allowed adults to facilitate these arrangements without meaningful judicial scrutiny of whether the younger parties had freely consented, or were being coerced, or were vulnerable, in ways the law had failed to account for. That's not a fringe observation. That's the core of what West Virginia changed in 2023, and what Ohio has been grappling with in the wake of this case, and what legal advocates for marriage age reform have been arguing for years. The laws permitted it. The laws permitted all of it. And now we are looking at a criminal case that begins, in some very real sense, not on June 30th, 2026, but in 2002 in Gallia County, Ohio, when the first of these documented marriages took place inside a legal system that required a signature and nothing more. Let me tell you about what happened with the truancy case in more detail, because I think it's the most concrete example of a missed intervention in the documented public record, and because it involves the people who are now defendants. October 2021. Gary Siders Jr. and Elizabeth Siders are named in truancy proceedings in Ohio. 6 of those in their household had not attended school a single day, not one day. And the school was 5 minutes from their home. When a family is named in truancy proceedings in Ohio, the process typically involves contact from a school official or truancy officer, an attempt to understand why the students aren't attending, and some kind of resolution, whether that's enrollment, documentation of homeschooling compliance, or escalation if the family doesn't cooperate. What happened here is that the family was contacted, and then they stopped responding, and then the case closed. I've been trying to understand what that means procedurally, what the options were at that point, whether someone made a decision that the case wasn't worth pursuing further, or whether the system simply didn't have a mechanism to force engagement once the family went silent. Former FBI agent Coffindaffer said that's just unacceptable. She didn't elaborate on what specifically went wrong, but her use of that word, unacceptable, is pointed. It's not the word someone uses to describe a tragic outcome that couldn't have been prevented. It's the word someone uses to describe a failure that had alternatives. Now let me be fair about something. The people who handled that truancy case in 2021 were working with what they had. They knew about 6 students not attending a school 5 minutes away. They didn't know what was inside that house. They didn't know what they would eventually find on June 30th, 2026. Their knowledge was limited to what a truancy case normally involves. Kids not going to school, parents not responding to contact attempts. The question Coffindaffer and others are now asking is whether the combination of what they did know, a family that had 6 students in truancy who stopped responding to official contact, who were paying rent and receiving state benefits but apparently not engaging with any educational system, should have triggered a different kind of response. A welfare check, an escalation to Child Protective Services, something that would have brought a different set of eyes to that address before June 30th. That question isn't answered yet. The investigation is still examining the full timeline. Prosecutors have confirmed additional charges are possible as the evidence continues to develop. And the truancy case is part of the documented public record that will presumably be part of what the grand jury reviews. Now let me talk about Tommy Pope, because he said something this week that I think represents the clearest public articulation of what's at stake legally as these cases move toward trial. Tommy Pope was the lead prosecutor in the Susan Smith case, one of the most significant child-related criminal prosecutions in South Carolina history. He's been speaking publicly about the Siders case, and when a NewsNation host asked him directly about Elizabeth's background, her entry into the Siders family at 15, her brothers claim that she was indoctrinated, the documented record of young marriages in this family. Pope gave an answer that was careful and significant. He said, "I don't know that it's a defense. Not it isn't a defense. I don't know that it's a defense." That's a former prosecutor who spent his career on the side of accountability, telling you that the factual picture around Elizabeth Siders is genuinely complicated enough that he can't dismiss the defense angle out of hand. He went on to say he thinks the background could factor strategically into whether the defendants are tried together or separately, and how the respective cases are structured. But let's stay with that phrase for a second. I don't know that it's a defense, because what it's describing is the central tension of Elizabeth Siders' legal situation, and its attention that the documented history of teenage marriages in this family makes more complicated, not less. If Elizabeth entered this family at 15, as the youngest spouse in a documented pattern of young marriages within this family network, if she arrived into that household without a full secondary education, without a significant peer network outside the family, without meaningful exposure to institutions or systems that might have offered a different frame of reference, then the question of what she understood about the circumstances she was in and what choices she had access to is not a simple one. That's not a defense in itself. Tommy Stolley, her own attorney, has been careful about that. He said his office isn't certain whether Elizabeth qualifies as a victim under the law. He said she doesn't necessarily characterize herself as a victim. He's pursuing the question of her status as a legitimate investigative inquiry, not as a predetermined conclusion. But the records that the Columbus Dispatch found, the records showing that Elizabeth was not the first, that this pattern of young marriages within the Siders family network predates her, those records matter to the legal question, because they establish a context that isn't unique to Elizabeth. They establish a pattern that was operating within this family before she arrived, that she entered into at 15, and that she has been inside ever since. Whether that context constitutes a legal defense is for the courts to determine. Whether it changes how any of us understand the situation is a different question. I want to talk about Gary Siders Sr. briefly because he is still in the hospital at Ohio Health Oblanes in Athens, still under a GPS monitoring recognizance bond, still undergoing a court-ordered competency evaluation. His attorney, Dorian Baum, is still pursuing two parallel tracks: the competency evaluation about his current state and the potential mental disease or defect defense about his state at the time the alleged conduct occurred. Ronnie Fletcher, identified as Gary Sr.'s son-in-law, confirmed publicly that Gary Sr. suffered a stroke at some point before his arrest that affected his cognitive functions and mobility. The competency evaluation will determine whether the level of impairment is significant enough to prevent him from meaningfully participating in his own defense. If it is, his case gets separated from the others and placed on a longer timeline pending restoration of competency. Christina Siders' attorney has now filed the second gag order request in this case, a motion seeking to restrict what can be publicly discussed about the case against Christina. Gary Siders Sr.'s gag order was approved by Judge Lena Featherolf Rogers. Whether Christina's will be approved as well is pending. Elizabeth's attorney Thomas Stolley said publicly that the language used by Attorney General Andy Wilson and other officials has complicated the case for his client by encouraging what he called bad speculation. What all three of those developments have in common is attorneys trying to contain the public conversation about this case before a grand jury convenes and before a jury pool is selected. The fear, and it's a reasonable legal fear in a case that has generated this much national attention, is that by the time this case reaches trial, it will be nearly impossible to find jurors who don't already have strong opinions based on what they've read and heard. That's a real challenge in Vinton County, which has fewer than 13,000 residents. Former prosecutor Payne said selecting impartial juries if defendants are tried separately may require bringing in jurors from neighboring counties. Meanwhile, the grand jury has still not convened. No indictments have been issued. Gary Jr.'s separate court date for the indecent exposure charges was scheduled for July 23rd. The investigation, according to prosecutors, is still gathering evidence and additional charges remain possible. Let me come back to what I started with, the truancy case in 2021, because I think it represents something specific about how this case could have gone differently, not a grand systemic failure that would have required completely rebuilding how Ohio handles welfare oversight. A specific, documented named case involving 6 individuals who weren't in school and parents who went silent. A case that closed when it should have escalated. Former FBI agent Coffindaffer put it plainly, that's just unacceptable. In a case where the truancy happened 5 minutes from the school, where 6 people who should have been in that school weren't, where the family stopped responding to official contact, that's the moment where something different could have happened. Instead, the case closed. The family continued, and 5 years later, law enforcement arrived to serve a misdemeanor warrant and found what they found. I want to be careful not to overstate this. One truancy case closing doesn't cause what was eventually found on Omer Road. The conditions that investigators documented weren't created by a truancy case closing. They existed, or began developing, before that case was ever opened. And they continued after it closed. The truancy case is one point in a much longer timeline. A timeline that begins by the documented public record, somewhere around 2002 in Gallia County, Ohio, with the first documented teenage marriage in this family network. But the truancy case is the most concrete, specific, documented moment where a system that existed to generate visibility into exactly this kind of situation engaged with this family, got a response that should have prompted escalation, and instead closed the file. That's the thing I keep coming back to. Not because assigning blame for a closed truancy case gets us anywhere useful, but because understanding what happened, the full sequence, the full documented pattern, is the only way to have an honest conversation about what needs to change. The marriage records, the truancy case, the indecent exposure charges that became a warrant, the warrant that became what happened on June 30th. Each of those is a point in the timeline. Each of those is a moment where a different outcome was possible. Most of them closed without producing one. And the records that the Columbus Dispatch found, the ones showing that Elizabeth Siders was not the first young person in this family network to enter into a marriage without the kind of scrutiny that might have asked whether she was there freely, those records are the earliest point in the documented public timeline. They tell you this pattern wasn't new. It wasn't something that started with Elizabeth's 2008 marriage. It existed before her. And it proceeded, documented in Ohio and West Virginia courthouse records, without generating the kind of sustained official attention that might have interrupted it. Those in the household who were removed on June 30th are with Ohio's Department of Job and Family Services. They are receiving care. That process is long, it's complicated, and it requires sustained support from people trained to provide exactly this kind of help. But it has started, and somewhere in the legal proceedings that are now unfolding, the grand jury that hasn't been scheduled, the competency evaluations, the gag order motions, the bond hearings, the ongoing investigation that prosecutors say may still produce additional charges. The full shape of what these records document will eventually become part of what a court examines. Elizabeth was not the first. The records prove that. And the question of what that means, legally, personally, for the investigation, for the systems that existed around this family and repeatedly failed to catch it, is still being worked out. The truancy case closed in 2021. The warrant was served in 2026. 5 years, 5 minutes from the school, and nobody inside that house was visible to anyone on the outside looking in. That's not just a legal question. That's the question that this community, these systems, and honestly, all of us who have been following this case need to sit with. If you want to follow this case as the grand jury convenes and the full picture continues to develop, subscribe to Crime Uncovered. We'll be here for every verified development. The records are there. They've always been there. Someone just had to go looking.